Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. We come to you today to break down the January 9th, 2026 opinion, Bowe versus United States. We previewed this episode and delivered oral arguments. Listen to those episodes if you want to learn more about this case. The Supreme Court held that federal law does not bar federal prisoners from seeking do-over claims in second or successive post-conviction motions. Justice Sotomayor's majority opinion clarified that the statutory claim bar applies specifically to state prisoners, not those in federal custody. The court also confirmed its own jurisdiction to review these authorization decisions through petitions for a writ of certiorari. This ruling ensures that federal inmates like Michael Bowe can pursue relief when subsequent legal decisions invalidate their original convictions. Before advancing, let me pause here to remind you to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email scotus.cases.pod@gmail.com. All right, let's proceed. Let me walk you through Bowe versus United States, a case that split the Supreme Court 5-4 on a question that sounds technical but affects thousands of federal prisoners seeking a second chance at challenging their convictions. Michael Bowe found himself serving 24 years in federal prison after pleading guilty in 2008 to conspiracy and attempted robbery, plus using a firearm during a crime of violence. That last charge carried 10-year sentence on top of everything else. But here's where things get interesting. The Supreme Court later decided in other cases that the crimes Bowe committed don't actually qualify as crimes of violence anymore. Think of it like the court changing the rules after the game already ended. Bowe realized he shouldn't face that extra 10-year sentence under today's law, so he tried to get back into court, but federal law makes this incredibly difficult. Congress passed something called the Anti-Terrorism Ineffective Death Penalty Act in 1996. Yes, that's really its name, which severely limits when prisoners can file second or successive challenges to their convictions. What happened next illustrates how complex federal law can become. Bowe first tried challenging his conviction in 2016, arguing the law was unconstitutional. The court said no. Then the Supreme Court struck down part of the law in 2019 in a case called Davis. Bowe tried again. The appeals court said no again, reasoning his other crimes still counted. Then in 2022, the Supreme Court decided Taylor, which knocked out Bowe's remaining predicate offense. Bowe went back to court a third time. Here's where it gets really technical. The 11th Circuit dismissed his request, saying he already raised this claim before under something called the old claim bar in Federal Law Section 2244B1. Think of this like a rule saying you can't bring up the same argument twice, even if the law changed in your favor after your first attempt. Courts across the country disagreed about whether this old claim bar applies to federal prisoners at all. 6 circuits said yes, 3 said no. This kind of split means your rights depend on where you happen to live, something the Supreme Court generally won't tolerate for long. Bowe petitioned the Supreme Court, but the government argued the court couldn't even hear the case because of another provision barring Supreme Court review of these authorization decisions. Justice Sotomayor wrote for a 5-justice majority, joined by Chief Justice Roberts and Justices Kagan, Kavanaugh, and Jackson. The court made 2 key rulings. First, on jurisdiction, the court said it does have power to hear these cases. The law says federal prisoners need authorization as provided in Section 2244, but Sotomayor's majority read this narrowly. The cross-reference incorporates only the certification procedures, not the ban on Supreme Court review that applies to state prisoners. Second, on the merits, the old claim bar doesn't apply to federal prisoners. Section 2244b(1) explicitly says it applies to habeas corpus applications under Section 2254, and only state prisoners file those applications. Federal prisoners file motions under Section 2255. Justice Sotomayor emphasized what lawyers call plain text interpretation. When Congress uses different words, it means different things. Congress deliberately distinguished between state prisoner applications and federal prisoner motions throughout the law. The majority also relied on federalism principles. State prisoners in federal court challenge state court judgments, creating tension between state and federal authority. Federal prisoners challenge federal judgments, so no such tension exists. Congress rationally treated these situations differently. Sotomayor stressed that Congress must speak clearly to strip the Supreme Court's jurisdiction following a 2003 case called Castro. The cross-reference here wasn't clear enough. Justice Jackson agreed with the outcome, but offered alternative reasoning on jurisdiction. She argued Section 2244b(3)(e) only bars review of properly made panel determinations, not dismissals based on incorrect legal standards. Jackson distinguished between panels that apply correct criteria, creating reviewable grants or denials, versus panels that apply wrong criteria, creating reviewable dismissals. Since the 11th Circuit dismissed Bowe's request using the wrong legal standard, the Supreme Court could review it. This interpretation protects Congress's detailed gatekeeping scheme by preventing courts from evading statutory requirements. Justice Gorsuch wrote for 4 justices, Thomas, Alito, and Barrett, on Part 1. The dissenters argued the court lacked jurisdiction entirely. Gorsuch pointed out that all courts of appeals have applied the certiorari ban to federal prisoners for 30 years. The provision bars both rehearing petitions and certiorari petitions in a single breath. Earlier Supreme Court decisions assumed this bar applies to federal prisoners. The dissent attacked the majority's clear statement rule as having no legal foundation. It comes from thin air. Gorsuch argued the rule isn't based on constitutional avoidance or any established doctrine. On the merits, the dissent traced a statutory chain. Section 2255H requires certification as provided in Section 2244. Section 2244b(3)(c) requires satisfaction of the requirements of this subsection, which includes the old claim bar. The dissent argued Congress intended to treat state and federal prisoners identically for successive petitions. This decision resolves the circuit split in favor of federal prisoners. They can now re-raise claims in successive motions that they previously raised, as long as they meet strict threshold requirements. But the practical impact remains limited. Few claims will satisfy the demanding requirements for newly discovered evidence or new constitutional rules. Federal courts retain other tools to address repetitive filings. For Bowe, specifically, his case returns to the 11th Circuit, which must now decide whether to authorize his successive motion under the correct legal standard, focusing only on whether his claims satisfy the statutory requirements, not whether he raised them before. The decision reflects the court's careful attention to statutory text and structure, showing how seemingly small differences in congressional language can have major consequences for thousands of prisoners seeking post-conviction relief. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email scotus.cases.pod@gmail.com.